Hi, everybody. Welcome to Square Off. Eric Gage is filling in for Mark today. And Eric, yesterday we learned that those on two wheels might have new access to highways. Yes, cyclists will be able to ride on the shoulders of highways that don't have on or off ramps, obviously to encourage more people to ride their bikes, and I think it's a great idea.
You know what? I don't really like this idea. Let's remember, those highways have speed limits of upwards of 80 kilometers an hour, not to mention they're not very well lit. Most of them are on country roads with hidden driveways and roads, transport trucks speed through them. I can go on and on, Liz, and I will, but we'll debate that later on Square Off.
This story is really hard to believe. Last month, the Supreme Court of Canada overturned a lower court ruling, reopening a case of two Edmonton men convicted of making and possessing child pornography.
Now, this is fascinating, Liz, and one really needs to pay attention to the details before judging. The men are 60 and 42. They were convicted of making child porn with two 14-year-old girls back in 2008. The teenage girls were runaways from a treatment center, and they consented to participate in the video with the two accused men and with each other. This is where the problem arises. The age of consent before May of 2008 was 14. It was only after May that the age was raised to 16. The offenses happened around April. So the Supreme Court said a new trial must be ordered to decide if the so-called private use exemption applies in this particular case.
Now let's bring in our legal expert, Jeff Manishen. He's a criminal defense lawyer who also worked as a Crown attorney. So Jeff, you know, we know the law is the law, but when the accused were 60 and 42, the girls were 14, it kind of seems plausible that the girls were coerced into these sexual acts or manipulated or maybe drugs were used.
Well, it's possible to infer that, Liz. That wasn't the way that the evidence came out at trial. The way the evidence came out at trial was that the girls consented. Now, part of the issue was, and I think one of the girls said this, that one of the reasons she consented was she was looking to get some drugs from the guy. We have to go back and look at the whole question of the private use exception with respect to child pornography cases. It's rare. This is not a case that's going to open the floodgates for a whole lot of other cases like these. This is a very rare case, and in fact, it will even be more rare now since the amendments in the law that set the age of consent from 14, raising it to 16.
So, but wouldn't it still be exploitation or abuse of children because of the age differences?
The age alone is not going to define the relationship, although certainly it can be a circumstance. The concept of it is this: where does the private use exception come into play with respect to child pornography? There are a number of elements that you have to have it done purely for the purposes of the private use of the individuals making or participating in it. It needs to be lawful sexual activity, and the people need to consent. At the time of these events, they were old enough to consent. Where the issue came up for the Supreme Court of Canada to consider was it in the context of it being a lawful sexual activity? The criminal code prohibited sexual activity with children of this age if the relationship was one which involved a relationship of authority or a position of trust, or one that had elements of exploitation in it. And that was the issue that really was not fully considered by the trial judge. If it was considered to be an exploitative relationship, then the fact the girls consented wouldn't matter because the sexual activity would not be lawful, and so the private use exception wouldn't apply.
Okay, so it comes down to this private use exception. What does that mean, and how do you prove it's for private use only? Because it's one thing if you get stopped and you're carrying pot, and you say, I wasn't going to sell, I was going to use it, and there's obviously not enough to sell. When it comes to pornography, though, how do you prove that you haven't shared it or that you weren't intending to?
Well, really what has to happen is the Crown would have to negative that beyond a reasonable doubt.
Okay, that's not a word I know. What do you mean by that?
We'll start with that there need to be some evidentiary basis for the court to have to consider, could it have been for private use? And in a case like this one, if what you had was girls who were overage, they were 14, 15, old enough to consent, and if some pictures were taken and at the time they were found, they were simply in somebody's home, in somebody's camera, or otherwise and not distributed and not circulated and no indication of any dissemination beyond simply they were present in somebody's home, there's a circumstance where a potential personal or private use could be argued. So that's where it comes into play. Where you see it far more often, Liz, in child pornography cases is where it's distributed, where the material is shared, where there are file sharing programs, where somebody's got a wide collection and clearly the sexual activity was not consensual because it involved other people. So you start with the concept of, if you have consent on the part of the individual or individuals participating, and where is the material when found, you start to get into the realm of a possible private use exception scenario.
So in this particular case, it's been passed around from court to court. The original trial saw these men acquitted because the judge accepted what we just called the private use exception. And then the Alberta Court of Appeal overturned that acquittal and convicted the men. And now the Supreme Court is giving these men a new trial. What happens in cases like this where we've seen every scenario sort of play out already?
Well, one of the features on that one, Eric, was that the Supreme Court of Canada disagreed with the approach used by the Court of Appeal. The Court of Appeal for Alberta, I think it was, added an extra element that said, well, what if it's not specifically an exploitative relationship, but there are elements of exploitation to it? I'm phrasing it very generally. Well, the Supreme Court of Canada said, no, you don't need to add an extra element. You look at, was the conduct lawful or not? The trial judge had not properly considered that.
So why did they do that?
You have it. Well, you have a trial. Why did the Court of Appeal do it? It was their interpretation of what should be imparted into the legislation. And that's what appellate court judges and trial judges do. They are called upon to interpret the law as they consider it, but that's why we have a measure, a method of appeal. And the Supreme Court of Canada said, no, that's not really the right approach in law. You have the elements to consider. The question is unlawful sex or not. You don't need to add an extra dimension. And
obviously the consensual part was a big component of this case. How do you prove, if it's a he said, she said, that it was consensual?
Well, again, if you had evidence, and nowadays, by the way, I should say, with the age of consent having been raised to 16, realizing child pornography involves people that are either are or are depicted as being under the age of 18. So for child pornography to begin with, there's our age limit. 16 and 17-year-olds are old enough to consent and yet be under the age. That's the condition precedent for a child pornography case. If they indicate that they did not consent and the individual who is involved in taking the private pictures, assuming it's to be the case, says they did, a judge would have to decide, has it been shown beyond a reasonable doubt they did not? Just like any element of the offense.
Well, it's going to be interesting to see where this one goes. I kind of want to switch gears for a second because there was another decision by the Supreme Court of Canada that makes it much more difficult for accused persons to get bail in this country. What's the story behind this?
Well, that's a case called St. Cloud. And we have in Canada, in our criminal code, provisions that justices of the peace and on murder cases, judges have to consider to decide if somebody should get bail or not. They have to consider whether it's necessary to keep the individual in because there's some concern that the individual may not appear in court if released. That's considered to be the primary ground. The secondary ground, whether there's reason to believe that it's necessary to keep them in the public interest, including the potential they might commit other offenses or interference with the administration of justice. Those have been used for a long time, and we understand those pretty well. The third ground involves that the detention is necessary to maintain confidence in the administration of justice. So now we've got a situation the person will appear and is unlikely to reoffend. The third ground can still be a basis to keep the person in, and that's the challenging one. Case law prior to the Supreme Court of Canada decision indicated that's really to be interpreted narrowly. The Supreme Court of Canada says, no, it's not so narrow. It's a separate ground in and of itself. What's the challenge for a judge or a justice of the peace? How do you ever measure whether the detention is necessary to maintain confidence in the administration of justice? They don't take opinion polls. There isn't expert evidence called on it. I would say to you that it's a really challenging ground for counsel to have to deal with, and it can potentially lead to people being detained under circumstances where the evidence for that may not be so strong.
Will this help expedite court cases, though? Given that we've got so much overcrowding, it's not, at a certain point, there isn't space to and the money to hold on to these people any longer than we absolutely have to.
It's never, there's a sound philosophical basis to say keep them in so they plead guilty and speed up the justice system. In fact, somebody's entitled under the Charter not to be denied reasonable bail without just cause. So that's a fundamental right under the Charter. Remember, too, the people charged with offenses are presumed to be innocent. And it's not in the public interest to have people detained for some period of time and ultimately acquitted. And the jails are certainly overcrowded. I've got clients in custody who've talked to me about the fact that the Hamilton Jail and others, you have 3 people sleeping in a cell meant for 2. And that is not uncommon in Ontario. That's what happens with respect to bail situations. And now this case could lead to more people being detained.
Right, and you can't get that time back either if you're found innocent.
Exactly right.
Yeah, that's Jeff Manishen, criminal defense lawyer. Thanks so much for being with us
Jeff.
today.
Always a pleasure.
When we come back, there has always been a common belief that it's the men that get the short end of the stick when it comes to family courts.
According to a group of family lawyers, though, that is not the case at all. And we're going to tell you why next.